Hey, everybody, welcome back to another special episode of Compliance Clips. Today, we're playing a game we like to call Due Diligence or Consequences. That's right, John. Kudos to Leo Barris and Truck News for getting this out in front of the industry. It seems we've got a bunch of bogus AZ licenses out there. And for our safety managers watching us today, your driver may be one of them. The MTO has started issuing retesting notices to a subset of Class A drivers, and to quote from the letter, due to irregularities discovered during an audit of your test provider, the Ministry of Transportation cannot verify that your AZ license and road tests were conducted according to Ontario standards. It goes on to say that in order for the driver to maintain their license, the affected drivers must successfully complete a vision and a knowledge test within 60 days of the date of the letter and a road test within 120 days at a driver test center. And by the way, they got to bring their own truck for the test. Now you might think, interesting article. Okay, on to the next thing. But, John, as you well know, we're in compliance, where every article can be looked at as a due diligence opportunity.
Wow, Rick. You must be a mind reader because, I read the same article and I was thinking the exact same things that you were.
Well, of course, John. After all, I wrote the script. But seriously, well, almost seriously, how many carriers do you suppose read that article and said to themselves, self, how many of our drivers might be affected? And what does this mean to me?
Well, that's a very good question, Rick, because if your only response was to read the headline and move on, you might already be in trouble. The consequences depend on what you know and do after you read that article. They aren't theoretical. They're operational, legal, and financial.
That's very true. So let's test your risk awareness. Welcome to a little game we're going to call Due Diligence or Consequences. Pick a number and discover your pitfall.
I'm ready, Rick. I'm ready. I'll take what's behind trapdoor number 1, Rick.
All right, John. You've selected the negligent hire.
Ooh.
You've hired a driver. License looks good. Abstract's clean. But nobody asked them where they trained or whether they've received that funny little retest letter from the MTO. The driver didn't say anything, and you didn't ask. 3 weeks later, he's in a cross-border collision. Injury involved, lawsuit pending. And then it comes about. That driver was ordered to do a retest before you hired him. His warning date was 2 weeks after you gave him the keys. And your hiring process didn't consider this issue. You didn't ask, and he didn't tell, and his license is bogus and downgraded to a G.
Ooh. That's right, Rick. No onboarding change, no statement from the driver asking them to inform you, the employer, if they received or if they receive one in the future. Now you're facing negligent hiring and supervision. I'm not just defending my driver. I'm defending my entire onboarding process here. And if that collision is in the US, as we've discussed many times in these little chats, US courts are increasingly aggressive in pursuing new or should have known type standards. A carrier operating in a regulated environment is expected to stay abreast of public safety advisories and respond accordingly. Failure to act equals failure of due diligence.
That's right, John. No onboarding change. No statement from the driver asking them to inform you, the employer, if they received or if they will receive one in the future. And now you are facing negligent hiring and supervision. Negligent entrustment. Plaintiff argues the carrier placed an unqualified or questionably licensed driver in a safety-sensitive role without verifying their legal status.
Negligent supervision, failure to implement oversight policies once a known risk was publicized.
Breach of duty of care, particularly relevant under Canadian tort law or in U.S. states applying commercial transportation industry standards.
Knew or should have known standard. In both tort law and compliance enforcement, employers are held to the standard of what a reasonable carrier in their position should have known and done. The MTO's public announcement places all carriers on notice. From this point forward, failure to investigate potential impact, issue guidance or declarations, document a process may be interpreted as willful blindness or negligence.
That's right, John. And in a post-collision context, particularly again in the US, the following questions might just come up. Did that carrier monitor regulatory actions affecting its drivers? Did the carrier ask whether any driver had been affected by the MTO's review? Was there a documented process or communication in place? And if the answer is no to all or any of the above, the plaintiff may successfully argue the carrier abdicated its responsibility to ensure their drivers were legally qualified.
Well, and then you bring in the FMCSA or DOT compliance risk, right?
No, don't want that door.
No. Even if the driver quietly completed the retest, a compliance investigator may ask, what process did the carrier have to identify affected drivers? How did the carrier validate its driver roster during this regulatory event? A blank response here may trigger citations for failure to maintain driver qualification files under 49 CFR 391.51 or to ensure continued qualification under 391.25.
So to summarize, should this play out in court, you may find yourself charged with negligent supervision and or negligent entrustment. And that opens the door for a nuclear verdict.
Ooh. And U.S. courts don't care that the license was technically valid at the time of hire. They want to know what you should have known. If the MTO made the risk public and you ignored it, that's a breach of duty of care. An open door for an expensive lawsuit.
Exactly. And when the FMCSA steps in after the bad crash, they're going to ask why you didn't have any protocols under the 49 CFR. Mm-hmm. They expect you to track safety-related regulatory changes, period.
Agreed. So if your hiring team hasn't updated the onboarding package, compliance pitfall number 1.
Ding. Okay,
Rick, it's your turn.
Okay, John. Well, you know me. I'm kind of methodical. I like to go things one step at a time. You pick number 1. So I'll pick pitfall door number 2, please.
Ooh, great choice, Rick. You picked the Silent Sam. Sounds kind of like you. Not. Yes, folks, it's that quiet driver that comes in, does his job, stays under the radar. Silent Sam. He's been with you a while, has a few hiccups and bumps, but he gets it done. He got an MTO letter and doesn't say anything. Either he doesn't understand what it means, or he thinks reporting it might get him pulled off the road. He's concerned he doesn't really know what to do in a real test, especially that brake measurement thing you hear about, all the time. The carrier only pulls abstracts every 6 months, doesn't run the free license validation check on the MCO website, and again, it's free. Then he ends up in a roadside inspection south of the border. License has been downgraded, DOT puts him out of service, lots of citation, SMS demerit points, load is now stranded, got to find somebody to come get that, and the client is not happy. Now you've got one more empty seat to fill. That's not just a disruption. That's a breakdown in internal communication. No policy, no driver briefing, no mitigation, could lose a client, will lose money on the load, especially if it's a time sensitive or temperature controlled cargo. Truck may be towed, more out of pocket expenses, driver is stranded, no way home, and you got to get another drive down there to recover this equipment.
Can I close that door and start again? Because that sounds like one expensive and embarrassing situation.
So true.
This is where policy matters, folks. If the company had issued a simple bulletin, if you receive a notice, report it immediately. That risk is managed.
But without that, you're now dealing with operational disruption, missed deliveries, CVOR points, and downstream legal risk.
And this is exactly why mitigation means more than checking a box. You need to create a declaration, you need to document your internal awareness, and you need to implement a clear response plan so that you can build a defensible position.
Well, you know what? Let's open door number 3. What could be behind it?
I don't know, but if you're talking about it, I'm going to guess it's related to something to do with insurance.
How'd you know? An insurance surprise. Yay! So we have a driver. He's involved in a crash. Happens to be an injury involved. Your insurer begins the process, dealing with the claim. Plaintiff's counsel produces an MTO retest letter in court. The license looked valid, but the driver was in the retesting pool. No one at your company knew a thing about it. No documentation, no oversight. Now the plaintiff's lawyer isn't just going after your driver. They're going after your whole safety program.
Uh-oh. And your insurance, like you're watching. Is that right? Is that what you're going to do? You're going to be thinking to yourself, and that little risk management division and the actuarials who come up with the premiums are going to be saying, these guys got no policy. They got no protocols. They got no risk management. Maybe we need to think about what we're doing for coverage with these guys next year.
Exactly. Could cause you some big troubles. This is where insurance exposure gets real. They may say, you knew about the MTO initiative. Why didn't you act?
Exactly. And some carriers are still operating under the assumption that validating a license once a year or semi-annually is sufficient. Because you know what? How much can go wrong in 30 days? Well, I think we're finding out quite a bit. And you're not in the clear. Yep. So not so fast, Roadrunner. That coyote's catching up with you.
Yep. Because the abstract validity isn't the same as legal defensibility, you may be insured today, but come tomorrow, this one's going to be on the agenda.
So in closing, here's some takeaways for our audience today. A valid license today doesn't mean your operation is protected tomorrow or your driver's license tomorrow.
Yep. If you haven't issued a driver declaration form, updated your onboarding process, and documented your internal response to the MTO action, you're already way behind. Insurers may view a failure to monitor regulatory risk as part of a pattern of weak safety culture, and defense counsel may be handicapped in arguing good faith if no written evidence of awareness or mitigation exists.
And what you didn't know, but should have asked, can and will be used against you.
Exactly. A carrier's failure to understand the implications of the MTO action, once made public, can in and of itself be cited as a basis for liability or enforcement.
That's right, John. The threshold for fault is not just what was known, but what should have been known and acted on by a prudent operator. Your due diligence is to take the steps that a reasonably prudent person would take in the light of the risks. So mitigate the situation now and make sure you've got your documentation.
That's right, Rick. You know what they say. If it isn't documented, it didn't happen. Mitigation equals documentation process. To avoid this kind of exposure, create a declaration form for drivers. Have them sign off it. Have them read it and have them sign off. Document the internal awareness of this issue. Add temporary policies or procedures for review. Log the action taken. Even if no drivers have ultimately, even if no drivers are ultimately affected, still need to document the actions. This creates a compliance shield, evidence that the carrier acted in good faith to manage a publicly disclosed safety risk.
So, thanks for playing, folks. This has been Due Diligence or Consequences. And this game is the game where the prize for shortcuts is a long and expensive road. Feel free to send me or John an email to request some samples, and we'll give you some text that you can drop and put your letterhead on to at least put you towards compliance with this one. All right, folks, so that's it for this month's Compliance Clips. Thanks for attending. And as we say goodbye, we'll just drop one last thought with you. Today's topic has been a great example of why you should do your diligence or
pay the consequences.
Till next time. Ciao. Hey, thanks for tuning in. We hope you found today's materials to be useful and you can put them to work. Be sure to subscribe to our YouTube channel so you never miss an episode. And if you've got questions from today's material, or maybe you're just looking to improve your safety and compliance game, please feel free to reach out to either me or John.